Civil law systems, comprehensive codes, and detailed statutes. Judges apply codified law and fact-finding without an emphasis on precedent. This is where things are just sort of generated from scratch, or, which is rare, or simply applying rules and laws put through. These are of, by, and for the people, depending on the area you're in, all the way to it coming down from the top, from the House, Senate, President, etc. Common law systems, courts of mostly case law, legal principles, etc. In some cases, theory. Most form precedent under the principle to stand by things decided, where judicial decisions serve as case law and or an authority to guide future court rulings when deciding subsequent identical or even similar cases. These come in two forms. One has to be followed, and this is referred to as a binding precedent, where it's been decided that previous courts having to make this decision because there's a controversy or a conundrum of how the laws are, or a law that didn't cover something before. Or it could be persuasive precedent, something they don't have to follow but can consider, and it's allowed for you to use a previous case and maybe stretch something from one thing to another. To make this accessible to the general public, to lawyers, and to courts, all of which have to have access to it, even though there's a presumption by most people that the public can't be allowed to have access to it, or there's a presumption that some of this must be secret. That is not acceptable. There are very few, unfortunately there are a few, incidents where things are kept secret, but when it comes to the basis for a law existing, or that the law exists, it's not allowed for it to be secret. Ignorance of the law is not a defense, but a refusal to publish a law, or being an unwritten law, sure as fuck is. Case law depends on these decisions being published and indexed as things called law reports, etc. The First Amendment protects the right of the people to petition for redress of grievances, which just means that they are allowed to demand to be heard on a federal level. Very few things you can do through a petition or redress for grievances or demand are actually going to be binding. On a city, county, and state level, however, they are. If you're in a state where it isn't, this is not considered a violation of our U.S. Constitution, but it is considered, at least by courts, as is stated above, to be in the spirit of you violating people's rights for redress. If the effect is that they're only heard, but they can be easily ignored on a federal level, it can't be ignored on the state. This is an argument that's been made, but this is not considered a binding precedent, more of a persuasive one. That can be changed. Let's move on. The individuals that can be demand to acknowledge they've heard your demands include members of the president's own cabinet, the president himself, the vice president, the House, the Senate, and, as you might imagine, going further down the line, one of these is the form of petition to demand for Freedom of Information Act, a streamlining version of the same demand. We demand to have access to the information about, let's say, some incident that happened in history. Well, we're holding that because it's under top secret status. Yeah, but that was under, January 3rd, 1901. We're demanding you open up the files. At that point, it goes under now what we call the Freedom of Information Act. Before that, it was petition after petition after petition. You get the idea. And forcing the ATF to publish their laws. That was a thing once. Because they had secret laws, which are not admissible in court. You can't do that. However, yes, you can have sealed documents done by a court, but they have time limits. They can't be perpetually sealed unless there's a overwhelming and compelling reason to do so. And they have to tell you, at least sometimes, what that's about. I was wrong about that at one point, just saying. Let's move on. But no, a sitting law that exists can't be secret. That's not a thing. Now, what other groups can be compelled? Here we go. State legislators can be called on to do things, representatives, and governors. Let's talk about compelling your state legislator to bite their tongue and say the words you shove in their mouth, or any other orifice you choose. Call a convention for proposing an amendment or some other action that representative, governor, senator, whatever legislator could do on your city, county, state, or federal level. They're your puppets. Do the Muppet maneuver. If 2/3 of the states then call on Congress to call the convention, which is a majority, that's 75%, then as specified by Congress, legislatures or conventions of 3/4 of the states, that was 66%, now we're at 75%, then could ratify the convention's decision. And again, at that point, they can vote to ignore what you told them to do. So, what's the next layer? This gets convoluted. Representative recall, or a recall petition, or a recall election, or recall referendum, or simply a referendum. Direct referendums, elections, petitions, or representative recalls are done by voter petition. Depending on what state you're in, you can or cannot force a vote. Indirect. You can compel your own official by referendum to compel a referendum be voted on. That's actually a different pathway. That means your representative is, again, you shove words in their mouth or up the other end, muppet the hell out of them, and make them say the words. Say it, Fred. I petition the state legislature to allow the people to vote against my best interest. There's only a couple of cases where someone's actually been made to do it, and by refusal to do it, you're in contempt of the people. That's an actual thing, depending on where you are. I'm not saying where. Let's move on, because I can't find reference for it. But contempt of the will of the people through vote and petition by vote happens. Normally, they just remove them from office and replace them with another puppet. Let's move on. This is a removal of an elected official, and also could require a change of law. But we're talking about removing an elected official from office for wrongdoings. Popular initiative, just saying we want him removed, or other, or compelling the individual to literally say the words you tell them to say, to propose it on your behalf as your representative, which is the reason they're called representatives. And it's a representative government. It's the most rarely used form of direct democracy through popular vote, and usually done midterm to compel basically someone who promised something and then didn't deliver. But this only applies up to and including the state level and on a federal level for your representatives, and only in states where they allow it. Obviously, the higher up the ranking you go, the less interference you can be doing to your representative. This is because obviously some malcontents in the state of Oregon could decide the Oregon representative to Congress or House or whatever, what representatives and legislators or whatever, could decide to just disempower them for no good reason. That violates the spirit of everybody else who voted them in office. But if it's the majority of the people doing this like a vote of no confidence or get out of office, we're sorry we put you in there, or buyer's remorse or voter's remorse, okay. Recalls first appeared in colonial American laws in 1631. They have a basis for existence, and they're done, well, on the East Coast, they're a little bit more popular, or at least more existent, maybe. 1921 is the first occurrence of a governor, North Dakota, Lynn Frazier, being recalled, that we have on record that I could find easily. 1988, Arizona Governor Evan Meacham was impeached, and this nullified a recall vote that was very likely to remove him from office, or not, we don't know. There was no vote done, so we can't say. 2003, California Governor Gray Davis was recalled. Every other incident is an example of by and for the people, maybe or may not be of the majority of the population, which is what a raw, direct democratic vote is supposed to be. Some are more equal than others. Most of these don't go through because they're brought disingenuously. One of them against the head of the politics in California. It didn't go through. It was beaten by almost the same ratio as the person was put in office. This was basically sour grapes. As you can see, this can be abused or it can be used. In some of these cases, again with an impeachment, the person was already in the process of being impeached. 2021 example. Of 529 recall elections or whatever that were run through, only 25 of them resulted in any change at all. They're expensive, they're time consuming, and they're much more subject to, shall we say, invalid processes and interference and intimidation. And also, they usually don't draw as many people, so a minority gets to make the majority vote. Or prevent the majority from voting, depending on what you're doing. Any system you put in place as a checks and balance can be abused. And has been. Not might or will. It was. Okay? See also gerrymandering. Congress under Article 2, Section 4 of the U.S. Constitution can initiate impeachment for treason and bribery. No Manchurian candidate here. Or crimes. But what is it used for that we've all seen? Misdemeanors is added in there for some fucking reason. Jaywalking. Presidential incapacity in the 25th Amendment is not necessarily very much invoked, and it shouldn't be considered unless there's obvious medical reasons for it. And in the case, there's only one case I know of for this that's a really good example, and it was mental incapacity, which was Ronald Reagan. And again, if you're not aware of it, Ronald Reagan stayed in office the entire time, was very popular, and basically Nancy and his cabinet were acting as a filter for what he said, waiting for the moments when he was fully sentient to communicate. Even at the end, between bouts of being, well, screwed up, and you could see examples of it, when he was clear-minded, he was Ronald Reagan. No, I don't like Ronald Reagan's policies, blah, blah, blah. But a lot of you are like me that miss, even though the guy was, at this point, mentally encumbered, was an effective president. And he would have been a 25th Amendment example. But when you have someone who's guilty of and convicted of 35 crimes, but you can't remove them from office on that basis, this impeachment process is bullshit. See also a certain Clinton being impeached, not for what you think, but for lying to Congress, which was treated as, by definition, not a felony, but a misdemeanor, simply because it was all about a performative act. See also, attempting to impeach Donald Trump twice and failing somehow because they wouldn't impeach him for shit he was actually guilty of. Parliamentary systems allow you to do no-confidence votes. How is this abused? Well, the head of the government will try to get rid of Parliament, or Parliament will try to get rid of the head of the government. None of these systems work except a direct action of by and for the people on a state-by-state level to compel all of your politicians to either A, obey you, or B, fire every one of them and stick Muppets in charge. And is that the most effective way to run your government? This is a question. I don't have the answer. This is like me doing a video on the Electoral College. I don't know how to do a better system. And other countries that do a better job end up with really cockamamie results. I'm worried about the effect. And for any of you who want to discredit any of these definitions, I deliberately leave links to Wikipedia articles. Again, it's not Wikipedia you look up. It's the citations they bring up. I even give one that's to Quora, which is a worth source you can use. But this is for the purpose of discussion. I don't have the answers. Do you? And again, in your state, are you allowed to either jam your fist up their butt and turn them into Muppets and make them do what you tell them? Or just only fire them? Or are you even allowed to do that when they do something really bad without going through the bullshit of an impeachment process, which is never, in my opinion, really used properly? Thanks for watching. Have a good day. Good luck with that. We're all going to need it.